great to see everyone here. My name is Priscilla Blow, if I haven't met you yet, and I'm one of the co-presidents of the Stanford Asian and Pacific Islander Law Students Association. And today we're going to be discussing the Supreme Court and the future of affirmative action. This conversation is prompted by the Supreme Court's recent hearing of the Student for Fair Admissions, or SFFA, versus Harvard, and SFFA versus the University of North Carolina cases. Both cases challenge the use of race as a factor in higher education admissions, and the outcome of these cases may overturn 40 years of legal precedent, which has allowed colleges to consider the race of applicants in admissions to promote diversity. We wanted to have this timely conversation because these Supreme Court cases have pushed the Asian American and Pacific Islander community into the public spotlight and political sphere in a way that really hasn't been seen before. Historically, in fact, a number of Asian American leaders have played a role in establishing the policy infrastructure that helped launch affirmative action in the 1940s, 50s, and 60s. And today, APIs are one community among many other racial communities, Black, Latinx, and Native American, and minorities that will be affected by the Supreme Court's decision. At Stanford and in California, we share a particularly unique experience. As a private research university, Stanford does have an affirmative action program, yet in California, voters have banned the use of affirmative action programs in California public universities since 1996. This conversation is meant to serve as an educational platform to discuss the cases before the court today and what they mean for affirmative action and diversity in America. So without further ado, I'm thrilled to introduce our panel for today. Professor Richard Thompson Ford is an expert on civil rights and anti-discrimination law at Stanford. He has written extensively about affirmative action jurisprudence, questions of race and multiculturalism, and the intersection of critical theory and the law. Wen Fa is a senior attorney with the Pacific Legal Foundation. His litigation focus is on equality before the law and free speech. He was the counsel of record on the amicus brief submitted to by the Pacific Legal Foundation and other organizations in support of the petitioner. Baboni Hawk is an experienced civil rights lawyer who founded Hawk Law and previously served as the litigation director of the Asian Americans Advancing Justice Los Angeles chapter for 8 years. She was the cooperating attorney on the amicus brief submitted by the Asian Americans Advancing Justice organization and 37 other organizations in support of the respondents. And Professor Bernadette Myler will be serving as our moderator for today's conversation. She is a scholar of American constitutional law and of law and the humanities at Stanford. Her research and teaching is at the intersection of legal history, law, and literature. Finally, we wanted to thank our co-sponsor, the Stanford Constitutional Law Center, who were instrumental in helping us organize this event, as well as the SLS event staff that greeted you at the door. We know that this event is one part of a larger conversation on our campus and in our society about race and diversity in America. So please join me in a round of applause to welcome our speakers.
So thank you so much, Priscilla and Morgan, for inviting me to be here to moderate this incredibly important panel, which I think will be a very informative discussion about these pending cases and what might happen in the aftermath of these cases. We're going to start out this evening by having each of our panelists introduce their perspective on the pending cases. And so we're just going to go from left to right, from Rich through Lavani. So if you want to start out, Rich.
Yes, hi. Thanks, everyone, for coming to hear us today. I was asked to frame the issue in terms of the existing legal standards, so I'll just say a few brief words about the history of affirmative action and the litigation that's led us to this point. As Priscilla mentioned, the term affirmative action is fairly old. It dates back to the 1940s, maybe even earlier. But the modern version of affirmative action really got started with the Nixon administration, interestingly enough, that started to implement affirmative action policies for federal contractors and institutions that received federal funding as well as governmental entities. And the broader term involved using affirmative action in order to avoid underutilization of underrepresented groups. So this idea of underutilization grew out of a context in which there had been a history of discrimination, obviously quite overt in the Jim Crow era, that had kept disfavored racial groups from the pipelines that would lead them to have access to networks, access to credentials, and access to training for particular types of jobs. And the idea of affirmative action was to make sure that the government and people receiving governmental funding didn't become what was sometimes described as a passive participant in this type of discrimination. You know, the classic case would involve a union that had been discriminatory and a company that hires from an all-union shop, or an apprenticeship program that had been closed to members of disfavored racial groups, and then an employer that required the apprenticeship for qualification for the job. In that context, there would be a relatively small and kind of artificially depressed number of people of color, people from the underrepresented racial groups available in the pool, and the mandate was to take affirmative action in order to avoid underutilizing what might be a much broader pool of qualified people, but people who wouldn't be hired through the normal channels, even if those channels were formally race neutral. Universities started to pick up on affirmative action for similar, if not identical, reasons. There was indeed, in the context of higher education, similar forces that would have suggested underutilization. But there were additional rationales, including, of course, the one that's now at stake in the legal controversy, that of diversity. So among the reasons that universities started to get involved in affirmative action policies included the understanding that a diverse student body was necessary in order to further the educational mission of the university, that they couldn't do their jobs as a university well if they didn't have a racially diverse student body, and they weren't going to have a racially diverse student body without considering race because of these factors that I just mentioned that were resulting in underutilization. In UC Regents versus Bakke, the first Supreme Court case involving affirmative action, the UC used a relatively crude form of affirmative action, but by today's standards, that involved something pretty close to a racial quota. And it was also clear in Bakke that or at least arguable in Bakke, that the candidate who sued would not have, or would have been admitted but for affirmative action. So Alan Bakke said, I was next in line, and because the admissions process was pretty numerical and rote, you could make that claim. In Bakke, Justice Lewis Powell, who wrote what's widely considered to be the controlling opinion, said, quota-based affirmative action is unconstitutional. It doesn't meet the legal standard, and I suppose I should say a little bit about the legal standard. The legal standard under the 14th Amendment, which for operative purposes is what controls in all of these cases, public and private universities, was that a racial classification would be subject to what's called strict scrutiny, and it would fail unless it was narrowly tailored to achieve a compelling governmental interest. So that's the legal standard. What's important to note about this is that there's no change in the standard depending on the effects or the intent motivating the racial classification. It's now understood to be a formal trigger. If you're using a racial classification, it gets strict scrutiny. It doesn't matter whether it's benign. It doesn't matter whether it's designed to promote integration as opposed to segregation, whether it's motivated by positive attitudes toward a racial group as opposed to negative racial stereotypes. The court doesn't care about any of that. Although those considerations might come back in sort of through the back door when you talk about narrow tailoring and compelling governmental interest, the justifications for using a racial classification. But you get this strict scrutiny no matter what as soon as you're using race. Bakke reinforces that in the context of affirmative action in higher education, so there's no different standard because the university's trying to integrate, but says if the university is using affirmative action to promote diversity, that counts as a compelling interest. It's tightly tied to the institutional mission, and if there's no other way to do it, it counts as narrowly tailored, so it survives. You need to have not quotas, but a holistic admissions process, and that's what for instance, Harvard did and argued for in what's now the famous Harvard brief that was quite influential on the court in Bakke. Okay, after Bakke, you have several other cases in which the Supreme Court narrows the scope of acceptable affirmative action each time, but doesn't invalidate it. So in Grutter and Gratz, which were decided in, help me out, 2003, the court struck down a more crude form of affirmative action in Gratz, but it accepted affirmative action for the purpose of establishing not only diversity, but a critical mass of members of underrepresented groups. So there was this new idea of critical mass, which then carried forward into a later case, 2013's Fisher versus Texas, where the University of Texas also argued that it needed affirmative action in order to have a critical mass. In Fisher, the new twist was that Justice Kennedy opined that in order to be narrowly tailored, the university would need to have considered race-neutral alternatives. So can you achieve diversity with race-neutral alternatives? That was the question. If you can, it's not narrowly tailored, and so you can't use race. But the University of Texas convinced the court that they could not achieve the critical mass through that. So you're getting kind of a narrowing of the range. Now we move to the Harvard case, and just quickly, I'll frame it with this observation. There are two distinct legal issues that face the trial courts in the Harvard case. One was whether Harvard discriminated against Asian American applicants quite independent of affirmative action. So it's possible that Harvard discriminated by using, for instance, the personality scores either as a cloak for discrimination against Asian Americans or by applying the standards in a racially discriminatory manner. If Harvard had been shown to do that, they're liable regardless of whether affirmative action is lawful. So you could raise that issue. Now, the trial court found that there wasn't sufficient evidence for that Harvard had done that. The second issue is whether affirmative action is valid. But these are two factually and legally distinct issues that are often confused in the context of discussions about affirmative action, and I wanted to flag that because one of the interesting moments in this conversation between the justices and Harvard's lawyer involves just this question, whether or not Harvard discriminated, and whether by discriminated we mean used affirmative action, which of course everyone knows they did, they don't deny that, or discriminated in the sense of applied their subjective care standards in a discriminatory fashion, which Harvard denied. Okay, so that's where we are with respect to Fisher versus Texas. I think I've already talked more than 6 minutes, so I'll stop there. Thank you.
Thanks so much.
Okay, thank you so much, and thanks for everybody for coming and for this very exciting panel. So my task is to present the main arguments of both the Students for Fair Admissions and also to present the view of our amicus brief, the Pacific Legal Foundation amicus brief in support of the Students for Fair Admissions in the Harvard and the UNC cases. So the Students for Fair Admissions, as I read their brief, they make two primary arguments. They want the court to, one, overrule the Grutter decision that Professor Ford was talking about earlier, and two, saying if the court does not overrule the Grutter decision, then the court should find that what Harvard and UNC are doing to be unconstitutional under the Grutter decision. So I'll take those in turn. First, in Grutter, the Supreme Court I'd say for the first time, there's some debate about whether it's a Powell plurality in Bakke or a Grutter decision that did it. But I think it's the first time the Supreme Court recognized the interest in diversity as a compelling interest for purposes of instilling racial preferences in education admissions. Now, this is an interest that I think, despite all the other disagreements, a lot of the proponents of affirmative action and also a lot of the detractors of affirmative action agree that diversity isn't really the main thrust of the justification for those programs. The argument has instead, before Grutter, been on whether it remedies past discrimination, but after Grutter, the Supreme Court, in this decision by Justice O'Connor, adopted this diversity rationale. So the Students for Fair Admissions argue that Grutter should be overturned because this is a one-of-a-kind exception to the Equal Protection Clause. You don't view diversity as a sufficient interest to justify racial discrimination in other areas such as contracting, public benefits, or even in K through 12 education. But diversity is somehow a compelling interest enough for a school to racially discriminate in the context of higher education admissions. The Students for Fair Admissions also argues that this is inconsistent with Brown versus Board of Education, which prohibited the use of race as a factor in deciding who to admit and who to deny access to public education. But public schools such as University of North Carolina are still using race as a factor in some cases to do just that. Finally, Grutter, courts applying Grutter, both the lower courts and the Supreme Courts, it's really led to mishmash of different decisions. You have the Grutter-Gratz dichotomy about what kind of uses of race are permissible enough. Schools are very confused about how to apply Grutter itself, and its assertion that racial preferences are necessary to achieve a largely non-racial diversity interest. The Students for Fair Admissions argues that's backed by really no real evidence. But even if the court does not overturn Grutter, the Students for Fair Admissions say that it fails strict scrutiny because it instills the type of racial balancing that the Supreme Court forbids. For example, Harvard uses these one-pagers to make sure that the proportionality of students from each group stay roughly the same from year to year. And a lot of the evidence in this case found that personality scores, this was a question that was posed to Harvard's attorney at argument by Justice Alito, and I didn't think there was a very clear answer to it. The personality scores largely disfavor Asian American applicants, and that's been played up in the media. But even besides that, even when you take out the personality scores, there's still a significant penalty for being an Asian American applicant at Harvard. So Students for Fair Admissions proposes race-neutral alternatives where Harvard eliminates its preferences for children of donor, alumni, and Harvard faculty who are overwhelmingly white and wealthy, and increases its preferences for socioeconomically disadvantaged, and contends that could lead to a similar demographic, but without expressly discriminating on the basis of race. Pacific Legal Foundation, my organization, we filed an amicus brief, a friend of the court brief, in support of the Students for Fair Admissions. We make three main arguments. First, we argue from a broad perspective that racial balancing is inconsistent with the promise of equality before the law. The Constitution protects an individual right, and it requires the government to treat individuals as individuals and not distribute benefits and burdens on the basis of their membership in a group. And in fact, in some of my cases, as I hope to talk about a little bit later, this fixation on proportional group representation at all costs actually requires discrimination in some cases. Second, regardless of how the court rules in these cases, in which, as Professor Ford mentioned, there's no real dispute that they are using race with respect to some applicants and giving a preference to some applicants on the basis of race. I think the next frontier is going to be in the context of what we're litigating now in K through 12 education at schools like Thomas Jefferson in Virginia and the specialized schools like Stuyvesant, Bronx Science in New York, where schools use facially neutral proxies for race that's animated by a discriminatory purpose and produces a discriminatory effect. So schools will eliminate standardized testing. They'll go to geographic preferences in order to achieve their preferred racial balance. But all the same, students are left out of the system on the basis of race. And finally, we advocate for ways to advance opportunity by protecting constitutional rights. It's an old joke among folks in the liberty movement that if we could make one change to the Constitution, we would add to the end of each provision in the Constitution the words, "and we really mean it." So I think some ways to advance opportunity by protecting constitutional rights are to eliminate barriers for the right of individuals to earn a living, such as laws that give established market participants the ability to veto their competitors from coming into the market and competing with them. We think that school choice, promoting more school choice so that schools can serve the individualized needs of individualized students, and also to dismantle a lot of arbitrary rules and restrictions in property, such as exclusionary zoning laws that prohibit individuals from moving into an area just because they are of a disfavored socioeconomic status. They want to live in disfavored housing, things like that. So we think there are ways to advance opportunity for all Americans without discriminating on the basis of race.
Thank you.
Thank you for having me, and thank you for hosting this really important discussion. So I am tasked with talking to you about Harvard's response to the SFFA brief, as well as talking to you about the amicus brief that the Advancing Justice Affiliates, Asian American Advancing Justice Affiliates, wrote in support of race-conscious admissions programs and upholding the precedents of Bakke and Grutter and Fisher that we've heard about. In response, Harvard makes the mirror arguments, which is they do believe that Bakke, Grutter, and Fisher should be upheld as constitutional, that race should be allowed to be used as one factor in determining college admissions, and they do advance the fact that their admissions program does meet those constitutional requirements. And I'll talk about each in turn. So with respect to the precedent, they do want to affirm that diversity is a compelling interest and universities should be allowed to use race to advance the goals of having an educationally diverse campus. I thought it might be an important thing to break down what diversity means, and I think that's important in terms of how they define it and how they have to make sure that it is a measurable thing in order to have their programs be upheld as constitutional. So those would include the importance of cross-racial understanding among students, breaking down stereotypes, reducing racial isolation and hostility, and training the leaders of tomorrow to meet the needs of an increasingly pluralistic society. Harvard believes that the precedents do apply strict scrutiny as they're required to do when they take race into account. And they do believe that the tests that are set forward in the precedents are workable tests and they have had measurable positive impacts. Finally, these are precedents over 40 years. And they believe that there is a substantial interest in upholding them and to turn around and overturn these very long-standing precedents would have a seriously harmful impact on sustained and interest that these universities have relied on for some time. With respect to Harvard's program itself, they first state that they do not discriminate against Asian Americans. There was a long trial in which our organizations were there. We represented some of the student amici, where they heard testimony of admissions officials. They had experts, multiple experts, and they had the actual files themselves, these application files that SFFA was able to identify and look through. And they couldn't point to a single file in which they could identify any Asian American who was discriminated against. And so they rely heavily on that trial record. The district court determined and made some factual findings that there was no discrimination against Asian Americans. The Court of Appeal, applying this very stringent clear error standard, also determined that there was no evidence of intentional discrimination against Asian Americans. And so that's their argument on that issue. With respect to their program itself, they do argue that they strictly applied the precedents in terms of how their program is created. So they look at race as one of many, many factors in order to establish a critical mass of diverse students in their population. Race is not used mechanically, so they're not giving points just because you're of a certain race. Nobody is required to identify which race they are from. and race can only be used as a plus factor, as a positive aspect of somebody's application. They did look at the issue of racial balancing, and their expert testified that the way that the statistics show up, that there is sufficient variation between years to show that Asian Americans, that cannot be a basis. There's no racial balancing going on that can't be a basis to identify discrimination against Asians. They claim SFFA didn't put on any experts to refute that. And again, that was a specific finding of the district court that there was no racial balancing. Finally, with respect to, I think Wen mentioned an alternative universe that SFFA created and had their expert run some tests around. They call it Simulation D. If you listen to the argument, you'll hear a lot about the Simulation D. And in that simulation, they basically stripped race. They increased the focus on socioeconomic background as a proxy for race. But what ended up happening was you had a 4% decline in the admits of African Americans. And so they thought that that was not acceptable in terms of the level of diversity that they wanted on their campus. So those were mainly Harvard's arguments. There's this issue also around this 25-year limit in the Grutter case, which has been talked a lot about, and I'm sure we're going to talk about that tonight. But in response to that, I don't think they really addressed that in their briefs as much, but because it just kept coming up in argument, they did think that it's not a strict limit, but they do believe in an endpoint, and they claim to be monitoring their use of race over time, and they do see that progress is being made, but they do think that as a compelling interest, diversity is timeless, and so they don't see that 25-year mark as a limiting factor for them. Moving on to the Asian American Advancing Justice brief, I just wanted to caveat that our brief did not take any position on whether or not Harvard actually met the strict scrutiny test under the precedents. We were really interested to hear some of the argument, and specifically the Solicitor General was, leaving some room or some possibility for the fact that the case could be remanded to address some of the race-neutral factors that Harvard might need to take another look at, specifically the ALDCs, which are the alumni, the legacy, the donors, and the children of faculty. And those are, on their face race neutral, but are known to have, a beneficial impact mostly for white applicants. So we would be very interested to see if that happens, because we do think that Harvard should be subject to the strict scrutiny of looking at race neutral alternatives. Similarly, we have identified in our briefs that things like SAT scores and GPAs are also racially biased. And so some of what Harvard is arguing is that they need to keep their SAT level scores at a certain level. We would question that, so we'll be interested in see what happens with that as well. With respect to the crux of our brief, we make three main arguments. One is, as Professor Ford mentioned, you have to look at affirmative action in a historical context and why it was created in the first place. And the history is starting from the 14th Amendment, going up through Brown and beyond. And as many people know, Brown was decided to ensure that we get past a situation where our schools are as segregated as they were back then, and unfortunately as they continue to be now. So even after Brown, we have faced a significant amount of resistance to desegregation within schools, and affirmative action really was a reaction to that. Because even though there was a number of additional litigation post-Brown to try to, force schools to desegregate, that wasn't happening. And I think the thought was that you can't just dismiss an entire several generations of students because the K-12 system is as messed up as it is, that segregation is as bad as it is. And so affirmative action was a Band-Aid. But it was a Band-Aid that worked. And it's crude, but it has been beneficial, in particular for Asian Americans. So from the time that the programs were started in the 60s and 70s up through the 2000s, you saw a six-fold increase in admissions of Asian Americans to higher education. And over time, some of that, was beneficial to Asian Americans, but even today, given, the very diverse, groups within the Asian American communities, there's still groups within the Asian American communities that need affirmative action, in particular Southeast Asians, have been very much the beneficiaries of affirmative action today. Looking at the Harvard program itself, we believe that, in the holistic admissions process that now happens, Asian Americans can still benefit from affirmative action, and they do. There's evidence in the record in the Harvard case that Asian Americans did get the plus factor for their race. And for all of these reasons, as we discuss in our brief, we think affirmative action has to be put in that historical context, and we have to look at the benefit that it has done and what would happen if the option of looking at race was taken away. Finally, we do talk about the diversity interest that's, we believe, still a compelling interest. We believe that helps all students on campus, including Asian Americans. The idea of cross-racial understanding and even diversity within diversity. Asian Americans are a very broad group of people. As I mentioned, there's certain Asian Americans that are more disadvantaged than others, more underrepresented than others. And so even just being able to learn from one another within your diversity group is an important factor to consider. We have intersectional issues with diversity, so not just race, but gender, socioeconomic status. So there's a number of reasons why we think that it remains a very compelling interest to make sure that we have diverse student bodies.
Thank you so much. So I think you've all set the stage with these extremely helpful presentations. And I want to, we've heard a little bit about the district court record and what was argued and what was established at the level of the district court. And I know that a number of students have probably listened to the oral arguments at the Supreme Court as well. So I just wanted to invite each of you to talk a little bit about what your impression was of the Supreme Court argument and whether anything had surprised you in any of the colloquies that happened there, or what, if anything, seemed to change your view on what the outcome of the case might be from the oral argument, if you want to start out too.
Yeah. I just realized that our brief also specifically talked about the issue of intentional discrimination against Asian Americans at Harvard, and generally we looked at the evidence and we agreed that with the district court and with the findings, and particularly having been at the trial and learned, kind of listened to the testimony, we definitely agree that there wasn't, evidence to support intentional discrimination. With respect to the argument and the Supreme Court, to switch gears, I wish there was something that surprised me, but more so than being surprised, I was just a little bit disappointed that kind of where we had heard the commentary going with respect to where we thought the court was going was actually going to come to bear. And I think the one that really sticks is that it does appear that this court is poised to overturn over 40 years of precedent, well-reasoned precedent, we believe, to take away the right for universities to look at race. Nobody at the argument, none of the justices said race doesn't matter. Nobody said that we don't have structural inequalities in our system. Nobody mentioned anything about diversity being a negative thing and that wasn't important for universities to have. But for some reason, they all came back, a number of the majority, the conservative six justice majority kept coming back to the idea that, race should just be off limits, because of certain streams of doctrine that has come through the precedents to the exclusion of others, which, clearly, there was also this tension in the argument about this wish that we could still have the remedial kind of justification for having some of these programs because of the realities that we face today, because everybody could not ignore, the BLM movement or anti-Asian hate or all these things that we're facing, and we need the tools to really address those. And for whatever reason, I just keep remembering back to Justice Roberts' famous line that the way to stop race discrimination is to stop discriminating on the basis of race, which is just incredibly tone deaf. And I just felt like that was a stream throughout the argument where we had these really interesting, robust discussions around why race is important, both historically. There was this great discussion around the Freedmen's Bureau, and the fact that racial classifications have been a through line through all of these cases. Brown versus Board of Education and the remedial, kind of impetus for the Brown decision and using racial classifications for desegregation, but then they just kept coming back to this notion that race is somehow off limits because it's, so untouchable. When we know race is such a huge reality in all of our lives and continues to be, and will probably continue to be for some time.
Thanks so much. Did either of you want to weigh in on things that surprised you or
Yeah,
about the
just a few things. I think, first, I think there are a lot of good lawyers on both sides of the argument, and it's really fascinating to me how they use certain words that I think mean pretty much the same thing, but they use them differently. For example, this distinction between, I think Harvard's lawyers were very careful to distinguish critical mass and racial balancing, when at the end of the day, my perception is what they're talking about is some sort of proportional group representation. They might view that as a good thing, I might view that as a bad thing, but at the end of the day, those are like two different words that the law, that the precedent has treated differently, but to my mind mean pretty much the same thing. And also, the fact that, they were very careful to emphasize that race is used as a plus factor, but if you are saying that affirmative action is necessary to get the student body to some sort of a desired racial demographic result, you're going to necessarily have to, if you want to achieve that goal, you're necessarily going to have to put your thumb in the scale, at least with respect to some applications. Another thing is, Students for Fair Admissions, obviously we supported them. I think they have a very excellent brief filed both at the petition stage and also at the merit stage. One thing that I think my perspective would differ from theirs is in the Harvard case in particular, they have a very skilled advocate, but he pretty much embraced this concept of racial diversity as an unqualified good. And I think that the Constitution demands equality before the law, and that means equal rights, and that means no one should be discriminated against on the basis of race. Race should not be a barrier to anyone from achieving their fullest potential. But if you talk about the sort of, racial balance as an unqualified good, I think in some circumstances you are going to have to make decisions and treat people differently on the basis of race. And I think it goes to, something that my co-panelists and I actually, one point that we actually agree on, and that when you talk about, these racial concepts, they're extraordinarily, broad, driven by, socio-political sort of factors. When we talk about Asian American, for example, we represent Asian Americans in some of our cases. And when the school says there are too many Asian Americans at the school, well, our clients actually have backgrounds. They have parents who hail from over 30 different countries. Asians as a whole represent over 60% of the world's population. So, every individual, from my perspective, is unique. But when you're talking about a crude group such as Asian American, it's a very broad and very, sort of a stereotypical term that's used. So I think people should be treated as individuals. When you talk about sort of things like segregation today, Justice Sotomayor mentioned, well, is there segregation today? No. Segregation means the government drawing barriers on the basis of race. What Justice Sotomayor was talking about was what people call de facto segregation, but I think that demeans the meaning of the term segregation as it's been historically used. When you talk about, individuals who live in communities that are not, as racially diverse, you can draw a few different conclusions from that. One, you can draw sort of conclusions that's sort of that stems from some sort of a racially discriminatory program, racially discriminatory government laws, and then I think in that case it would be appropriate to snuff out to where there has been intentional discrimination in those cases. But if you're talking about racial, a community that's not racially diverse because of the individual choices of individuals in that community for race neutral reasons, then I don't think you can equate that with de jure segregation in the past. And just to give one example of how we've seen this myopic focus on racial diversity play out in some of our cases, we challenged a program in Hartford, Connecticut in 2018 that involving a racial quota that fortunately no longer exists today. But our clients were 7 Black and Hispanic families stuck in failing neighborhood schools in Hartford, and they try to get into world-class magnet schools that routinely send their kids to Ivy League universities and schools like Stanford. They were on the wait list of those world-class magnet schools. And those magnet schools in total had over 1,000 empty seats. Now you're wondering, how could that be? It's because those schools were governed by this racial diversity quota that required 25% of the students at those schools in the name of racial diversity to be white and Asian students. But because they could not get enough white and Asian students to come in from the suburbs, because Hartford was largely Black and Hispanic, the city of Hartford, because they could not get enough white and Asian students to come in from the suburbs, they had to leave those seats empty rather than to admit promising students who were Black and Hispanic off of wait lists and give them a better opportunity at a better future. And I think that's, regardless of where you are with the affirmative action debate, I think everybody would agree that is just one example of how this myopic focus on racial balance stifles individual opportunity.
Not much surprised me. I mean, just to answer the question, not much surprised me about the oral argument in the case. I think the composition of the court makes it fairly clear that where this is headed. I was a little surprised, perhaps, and I guess disappointed might be the other word, by some of the way the questioning went that collapsed these two distinct issues that I mentioned before. One is whether or not Harvard discriminated against Asian Americans, either under a cloak or by using a discriminatory application of neutral criterion. And then the other is affirmative action. And I do think it's really problematic the way that all the conversation around this race has collapsed these two issues. And the Supreme Court, particularly in the colloquy between Seth Waxman and Justice Roberts and Justice Alito, participated in collapsing this. So there was a moment where Alito was pressing Waxman on Harvard's discrimination, and Waxman was resisting. He's saying, no, Harvard didn't discriminate. And now Harvard's, aside from whether you describe affirmative action as a form of discrimination against Asian Americans, which is a questionable framing, all the other questions of Harvard's discrimination had been settled at the trial court level with the ample discussion and factual record that we've heard about, and it was just inappropriate to reopen those factual questions at the appellate level. It muddied the waters. Though even if you think that affirmative action should be invalidated, and that's clearly within the Supreme Court's purview, what's not in their purview is to confuse the issue and make it seem like these two are the same thing. Someone who teaches employment discrimination and who's taught the equal protection, one of the things that's true about proving race discrimination, intentional race discrimination, is it's really hard to do. And it's hard to do by design. And for good reasons and for bad, it has been made that way. So the trial court, in applying the law as it exists to the factual record in front of it, said there is insufficient evidence to find that Harvard discriminated. Now, I'm going to be the first one to tell you that doesn't mean they didn't. It means that there's not enough evidence under the existing law. I'd love to see the law reformed in such a way that it's easier to prove discrimination. But if that's what we're going to do, we need to do it not just in cases of affirmative action, but across the board. And if that's what we're going to do, and we're going to move towards something that looks like a disparate impact standard for college admissions, then every single other aspect of the admissions process has a disparate impact. And that's not legally actionable right now. I don't think anyone's suggesting that it should be. So those two questions shouldn't be confused. Whatever the outcome of this case is, and whatever whatever you personally think about whether an affirmative action program should be lawful.
Thank you so much. So a lot of you have already talked about sort of the writing in the tea leaves and the fact that it seems like the Supreme Court is poised to potentially overturn affirmative action in these cases. And so my next question is really about how universities could respond and what kind of leadership universities should exercise in the wake of whatever decision the Supreme Court reaches in these cases. So, Rich, do you want to start out?
Oh, I'm sorry. Could you just repeat it?
Yeah. So I just, if the cases come out the way that they seem to be headed in terms of potentially overturning affirmative action or overturning the 40 years of precedence, or even if they potentially come out somewhat differently, saying that Harvard didn't meet strict scrutiny or something of that sort, what universities will be left in a difficult position. And I'm just wondering if the panelists have thoughts about kind of what kind of leadership universities could exercise in the wake of the decision.
Of a decision that invalidates affirmative action, yes. Well, I think the universities could do a number of things. I mean, I guess, to my mind, one of the most important things that everyone could do, including university leadership, is to not confuse the formal outcome of a Supreme Court decision with their sense of justice. That in our society, we've got a habit of looking to the courts to give us our sense of justice and to define what counts as justice. And I'm afraid I have to say that I don't think that faith is warranted. So you have to obey the letter of the law, but you don't have to like it, and you don't have to take on what the court's saying is just as what you believe is just. That's one thing. The other thing I'd say is that if universities do have a number of admissions policies that have a racial impact, as I mentioned. They have the alumni preferences, they have the regional preferences, they have the athletics preferences. All of those were shown to have a racial impact that depressed the number of both Asian American and also African American and Latino applicants. Those can be revisited. They're not legally required to do it, but they could. And if they're committed to diversity, they should. There is, growing evidence that the scalable numerical indicia of academic merit, and I want to emphasize that they're not identical to academic merit, they are proxies for it. And they're imperfect proxies for it. And those could be revisited. That's not outside the realm of possibility, and it's not something that would be engineering the class in order to produce a racial outcome. That would be looking at whether or not what we're doing now has a racial impact and whether we can remedy or correct for that racial impact. And I think post-COVID, a lot of universities have already started to look into the extent to which they're going to rely on standardized tests. So those are things that universities could do to lead in the, in the aftermath of this decision.
Thank you.
Yeah, so what I think universities will do is going to be similar to what Texas did in the wake of a decision from the 1990s, a Fifth Circuit decision from the 1990s called Hopwood. And that's to implement some sort of facially neutral plan that, in my view, is also driven by a discriminatory purpose and produces discriminatory effect. So usually those come in Texas. In the case of the University of Texas, they resorted to a top 10% plan with, taking the top 10% of high school applicants from each of the Texas high schools. In some of the other K through 12 cases that we've litigated, schools, in order to facilitate their desired racial balance, they've either eliminated standardized tests or they've changed socioeconomic preferences to leave out low-income students of certain racial groups that they believe to be overrepresented at those schools. And of course, I don't think the schools should be doing any of those things, and that's why we litigated against that. I think there is there is an opportunity for maybe it's schools or maybe it's other institutions, to find ways to eliminate government barriers to opportunity. So I guess focused on the school aspect of it, I think that some of the things that schools could do is to maybe invest in more programs from the K through 12 context to provide more educational opportunities for children at a younger age, and to prepare them for elite schools like Stanford and like Harvard and like UNC. Other things that schools could do is, I think when I think about the concept of schooling in general, I think of a lot about a very unwieldy and bureaucratic process in some cases. I think that everybody takes some tests. Most people, they choose one of 5 majors. But what about trade schools? What about different types of educational institutions for people who want to do different things? I think there should be more programmatic choices at schools and more schools to take advantage of the unique needs and aspirations and frankly abilities of each individual student. So I think that's what schools would do.
I guess I would just concur with both of my colleagues about the fact that schools will be moving towards more kind of race-neutral approaches, but I think as was talked about at the argument and as some of my colleagues mentioned, we don't really see those as particularly race-neutral, and it's likely that race is still going to be considered in some way. There was a lot of discussion at the argument around using the essays as a way for individuals to talk about their race and contextualize their experiences. But I do think that we do have to step back and regardless of what happens with this case, we really need to look at the broken nature of our education system writ large, particularly in the K through 12 arena, and the under-resourcing of schools, the massive segregation that still exists in society. And we can't kind of really just focus on affirmative action at the tail end of the experience, but we really need to have really more of an investment in schools, and in racially diverse communities and socioeconomically depressed communities, and make sure that we are really focusing our energies there as well. But again, with respect to what universities will be doing, I think they can and should be continuing to look at where the disadvantages lie, and I think you will always still be finding them in certain racially, specific communities, African American communities, Latino communities, and it's going to be incumbent on universities to not leave these communities behind. And so we're looking to make sure that we continue to, whether that be in the courts to litigate, challenges to what we think will be race neutral, what will be, kind of put forward as race neutral options, but some of my friends will sue that and say, no, that's actually race conscious. Under Arlington Heights, there's a whole different body of cases where, you will be finding these challenges brought. So I don't think we're going to see this issue going away in terms of the importance of race.
Thank you so much. So we had a couple of students send in questions in advance also, and I want to get to at least one of those, and it builds on some of the discussion here. One of the students asked whether the court is expected to draw any explicit distinction between socioeconomic equity and racial diversity, and I think that kind of builds on what you were saying in terms of steps that the universities may be taking in the wake of a decision here. So do any of you have views on whether the court will explicitly reference socioeconomic equity in the opinion?
I think they may. I think that would be a mistake because I think there's an assumption that focusing only on socioeconomics is going to get you the racial diversity that you're looking for. But there have been studies to show that that's not the case. There's also a stigma associated with assuming that people of a certain socioeconomic group will result in a certain racial composition. So there's if there's no race consciousness, but there's a number of racial minorities, everybody's just going to assume that all people of color are poor people, which, as we know very well, is not true. So there's all sorts of other problems with just focusing on socioeconomic status. It's obviously very important, and there should be, a focus on that. But I think it would be a mistake if that's where they were going. Right now, they are two factors under these holistic programs that do get their own plus factors, and I think that that's appropriate.
So let me tease out a couple of my answers. I actually agree, even though Professor Ford and I think, disagree on many of the issues in this case. I agree wholeheartedly with his observation that, sort of the legal doctrine can sometimes be distinct from what is the morally right answer in any given case. So two answers. One, in terms of, I think the court is expected to draw a distinction. Socioeconomic preferences, as I mentioned earlier, is one race-neutral alternative that is frequently invoked by the challengers in cases like this one. And you see it in part in cases involving the percentage, or in percentage plans and things like that. And as a legal matter, whether those are susceptible to equal protection challenges are going to be based off of that Arlington Heights framework, whether they have a discriminatory purpose and produce a discriminatory effect. But my observation as a moral matter is that, when you're talking about schools, I think schools should be just looking to get rid of preferences as a whole. There's a lot of empirical research saying that even for the purported beneficiaries of preferences, they actually harm those purported beneficiaries, when they're actually at those universities. So I think regardless of whether you're talking about preferences for low-income students, whether you're talking about preferences for high-income students, whether you're talking about preferences on the basis of race, I think why don't we just focus on this idea of merit and individuals who are able to attend schools based on their achievements and their aspirations.
I guess just quickly, I think that the use of socioeconomic status, it comes up in two distinct ways with respect to affirmative action. I mean, one of them is that it's a race-neutral alternative. So we'll look at, we've already discussed that. I think the other way it comes up, which can be a bit problematic, is that it's assumed that the reason for affirmative action is to overcome disadvantage generally, and that socioeconomic advantage is the real disadvantage. And therefore, if we're doing affirmative action to overcome disadvantage, why don't we look at the real disadvantage and not race? And I think that's a mistake for a lot of reasons. One is that certainly you could look at both, but racial issues in our country are distinct from socioeconomic ones in important ways. And also the purposes of affirmative action aren't just about overcoming disadvantages, but they're about correcting for flawed proxies for merit. And that was the idea of underutilization that started affirmative action, and I think it's still valid today, so that the question of diversity is fused in some way with the question of why it is that you would need to consider race in order to have a diverse student body. And that goes back to these potentially flawed proxies for academic merit and promise. And then there's the separate question of when the university looks at things that aren't academic promise, but are other types of merit. So I think defining what exactly counts as merit in the higher education context is very difficult, because the universities would argue quite forcefully and with some justification that being good at a particular sport counts as merit. It's not academic merit, but it's a different kind of merit. We care about that. And they would also argue, I think, and increasingly they would argue this more forcefully, that scalable indicia grades and test scores are flawed proxies for merit, and we're trying to figure out, we use them because they're the best we've got, and they're cheap and easy to use, but we know they're flawed, and so we're also trying to make adjustments, and we think that race is one of the predictable ways that they're flawed.
Well, so I think we've reached the end of our time, but this has been a wonderful conversation. Thank you all so much. Please join me in thanking the panelists.